The former Chief Minister of Delhi, Arvind Kejriwal, and the former Finance Minister, Manish Sisodia, along with 21 other accused, may have been discharged in the Liquorgate matter, but the Central Bureau of Investigation is trying to get the order overturned. The agency had moved the High Court to challenge the trial court's discharge order, but now there's been a twist to the tale as Arvind Kejriwal wants the case to be taken away from Justice Swarna Kanta Sharma's bench, who's hearing the case in the Delhi High Court. The Aam Aadmi Party chief is set to argue the case himself in the High Court today, seeking a recusal on the part of the judge. Let me, if I go across to my colleague Bhavtosh, who will get us some more details now pertaining to what's been happening in the High Court already. We're also being joined by Priyank as well. Let me go across to Bhavtosh first and foremost. Bhavtosh, this is an important case because Arvind Kejriwal apprehends that the hearing in the Delhi High Court may not be conducted in an impartial and a neutral manner. That's his apprehension, and therefore he sought the recusal on the part of the judge hearing this case, Swarna Kanta Sharma, and sought this matter to be placed before another bench. Take us through the details and what's already happened in the court so far, because in the previous hearing in the Delhi High Court, Bhavtosh, the order on the part of the trial court seeking an investigation into the CBI's official has been stayed as well, and the judge also claimed that prima facie the trial court's observations appear to be prima facie erroneous.
Yes, important day as far as the case is concerned. Arvind Kejriwal went inside the Delhi High Court around 30 minutes back along with other accused, particularly those belonging to Aam Aadmi Party. He wants to argue the case on his behalf, and what has happened so far in the case is a dramatic turn of events, with the trial court in fact discharging not one or two accused but all 23 accused in the alleged excise scam. He said that if trial starts in this case, it would be manifestation or the miscarriage of justice as far as the case is concerned. CBI then filed an appeal in the High Court, which was a 900-page appeal, in which they have said that the trial court judge, Special Judge Jitendra Kumar, carried out a mini trial and his order was perverse in nature, and that it should immediately be stayed. Solicitor General Tushar Mehta argued on behalf of the CBI and asked for immediate stay. Justice Swarna Kanta Sharma, in fact, had said that statement of some of the witnesses was in fact not appreciated, and she also put a stay on the Enforcement Directorate case, virtually saying that the Enforcement Directorate case should not be in fact in any way be quashed. Now, Siddharth, one of the reasons was that because since the CBI case was completely being quashed, there were apprehensions that the money laundering case would also be in fact completely be closed. And that's the reason why Arvind Kejriwal then went to the Supreme Court, saying that Swarna Kanta Sharma should not be hearing this case. But Supreme Court did not take up the matter, and that's the reason why Arvind Kejriwal and other accused have now approached the High Court whether she will hear Arvind Kejriwal, because this is very similar to what had happened earlier in the Supreme Court when Mamata Banerjee argued on her behalf for the West Bengal government. Chief Justice of India had heard her,
yes,
and one has to wait and see what will happen in the High Court now.
Absolutely, stay with us, Bhavtosh, because this recusal plea comes against the backdrop of what took place on the 9th of March, when the Delhi High Court first heard the CBI's challenge to the discharge order on the part of the trial court. On that day, the High Court issued notice to all the accused, and after hearing the prosecution, had made certain key observations on the trial court's order. And those observations, of course, have been quite significant as well, because the court also ended up staying the investigation ordered on the part of the trial court against erring CBI officials too. Let me go across to Priyank. Shivam also joins us, but first and foremost to Priyank. Priyank, one important observation that had been made by the Delhi High Court in its previous hearing, and that's on the 9th of March, was the fact that all the accused in this particular case who had been discharged had been given an opportunity by the Delhi High Court as well to present their case, but they did not make an appearance, and therefore the Delhi High Court was compelled, following the submissions that had been made by the CBI, to stay certain observations that had been made by the trial court, especially in the context of ordering investigations against erring CBI officials in this case. Subsequently, of course, Arvind Kejriwal has decided to escalate the matter by claiming that he apprehends that he might not be at the receiving end of a fair trial in the event that the hearing continues under the same bench in the Delhi High Court. Take us through everything that's happened now and the implications of the plea that's now been moved by Kejriwal as well, who will present himself in court today.
Yes, at least that Times now has accessed the legal strategy of Arvind Kejriwal and the 28 accused before they can actually start their submission before the Delhi High Court. So this is an exclusive set of information which we have managed to access, which will further decide the further course of argument which is going to happen in the court. You can remember Mamata Banerjee, the serving Chief Minister of the state of West Bengal, had appeared before the Supreme Court, and now this is the former Chief Minister who will in person argue before the court itself after the CJI has rejected their approval, their proposals that Justice Swarna Kanta Sharma should recuse herself from this particular hearing. What I have personally got to know that this particular argument will be particularly based on the argument which Arvind Kejriwal is going to make, that this case is certainly a case of preconceived notion by Justice Swarna Kanta Sharma. Hence, she could recuse herself from this particular hearing. And the argument which they are going to make is the 9th of March hearing, the day which you just mentioned, that when the 28 total accused were not present, only CBI was present in the court hearing at the Sessions Court, then how is it possible that the order could be pronounced? And then it will go on further that no particular time period was given to the accused to file their reply, and they will also quote that how many times Justice Swarna Kanta Sharma had given 2 months, 3 months of time period for those accused to reply in this particular application copy. They will also mention that this order copy is of 600 pages, but we were only given a time of 1 week to reply on this particular thing. So Arvind Kejriwal is going to make a dramatic, turn of event unfold inside the High Court hearing, where he will try to present it before the court itself that the judge should recuse because she has a preconceived notion. Arvind Kejriwal is also going to make one point to that when the ED officer, when the CBI officer himself was supposed to go through an investigation which was ordered by the Session Court, he had not filed any reply before the court.
Okay.
He had not moved to the court against the court order which was talking about any action against him. How is it possible that the ED case could have been put on hold by the same court, which is going to make it more obvious for the Aam Aadmi Party that this case was dealing with the preconceived notion? He will talk on 3 particular points. Point number 1, 28 accused are not satisfied. Point number 2, 600 pages order copy was not given sufficient time to be replied, and the preconceived notion is going to be the word which is going to pop up time and again whenever Kejriwal will be arguing before the court.
All right, we'll wait and see as to how things transpire in the Delhi High Court. Bhavtosh, Priyank as well as Shivam, thank you for all the updates that you've given us. Just to reiterate what Priyank has just said, which is the source-based information that we've now managed to access about Arvind Kejriwal's strategy in terms of arguing this particular case. He's claimed that the 28 accused and the case against them is completely fabricated. It lacks merit. He's also likely to highlight that the trial has gone on for 4 months. How can the order be given within a few hearings? One of the key points in his legal strategy will be that none of the accused were present on the 9th of March, raising questions about how adverse observations and decisions could be taken by the Delhi High Court without hearing their point of view. He is expected to also contend that the judge had arrived at preconceived notions without giving the accused adequate time to argue the matter. So that's, of course, the sum and substance of what he's likely to argue in court. Now, let's turn our